Hi there, my name is Caleb Tingstad. I am a law clerk at Beresford booth here in Edmonds. And today we're going to talk briefly about prejudgment writs in the state of Washington and considerations associated with those prejudgment writs. We will go ahead and get started here with just generally discussing what a prejudgment writ is. It is a statutory mechanism where the court basically orders a plaintiff or gives a plaintiff security prior to final judgment. This can be a very important club for plaintiffs to use, particularly when there is probable cause or in some cases a likelihood of success on the merits. And if a prejudgment writ is obtained and ordered, it can be a very powerful tool to both secure judgment beforehand and also convince the defendants to come to the table early on and discuss settlement. As I said, the prejudgment writs come from statutes. In Washington, the statute governing attachment is under 625 and garnishment is under 626. Attachment is basically, just seizure of a defendant's real or personal property, whereas garnishment more pertains to actual dollars and cents. Speaking of bank accounts and wages and that sort of a thing. And while there is two separate statutes, the procedure by which to obtain writs of both attachment and garnishment are substantially similar, and the considerations for when they are appropriate are also substantially similar. In fact, the grounds for issuance, which arises out of, actually comes from the attachment side of the statute. Specifically, it's 625.030, applies to both attachment and garnishment. And I have up on the screen for you here just a couple. I think it's a list of 10 in the statutes, and they all sort of arise out of very similar sets of facts. It's usually when a defendant is intending to defraud a plaintiff or is looking to abscond from the state, turn and run, that sort of a thing. And then also in breach of contract actions. And one thing I would like to say on this point too is that prejudgment writs can be really, really useful, particularly when time is of the essence, which is why you look at, which is important when considering the grounds for issuance. And it can even be be an even more powerful remedy than a temporary restraining order, because the court is actually giving you an affirmative club that you can go and use, as opposed to you just asking the court to prevent someone from doing something. And prejudgment writs can be issued both with or without notice. And so in that sense, there's somewhat parallel to a temporary restraining order. However, if you're going for a no notice writ, there are several considerations that you have to meet. You either have to only attach real property, or you have to be able to show that the defendant is intending to defraud you as the plaintiff, or that the defendant is looking to turn and run from the state. And this is all within, you have to demonstrate all of this under the guise of probable cause. I will say too, within no notice writs, for those defending, I think we go into considerations for defendants here. Important to consider constitutional issues. One thing that you see discussed very frequently within the cases is due process, and whether it is proper to be able to seize a defendant's property without giving them their day in court, which is one of the things that a no-notice prejudgment writ of attachment is seeking to do. And so for those defending against prejudgment writs, I think that is a very important consideration if a no-notice route has been attempted. Now, going on to if there is notice that is provided, the protections for defendants are built into the statute by way of the plaintiff having to post a bond. And so, in a sense, this is supposed to protect the defendant in the event that a prejudgment writ of either attachment or garnishment is wrongfully issued. Now, excuse me, this can go both ways because I believe the statute sets the minimum of a prejudgment writ bond at $3,000. If you are a plaintiff attempting to successfully obtain a prejudgment writ, you are going to want to have that bond as low as possible so that in the event the writ is wrongfully issued, the liability of the plaintiff is as low as possible. Whereas if you are the defendant, you are going to want as high of a bond as possible. And the amount of the bond is something that is squarely within the view of the court, the discretion of the court, and is something, and the court will consider how much is being asked for in the value of attachment or garnishment, or it should consider the value of the attachment and garnishment when looking to determine how much the bond will be. And for defendants that are kind of stuck in a sticky spot in terms of the merits of their defenses, seeking to have the plaintiff post as high of a bond as possible is while not necessarily a complete defense to a prejudgment writ, right? I mean, it has nothing to do with the merits, but is just one of those practical levers that defendants can use to sort of further protect their interests and make it a little bit more difficult for plaintiffs to go about obtaining their bond or obtaining prejudgment writs. And I think that is all that we have for today. The prejudgment writ process is something that is heavily statutory and requires both plaintiffs and defendants to really walk through a series of steps before getting to the final outcome. And no process is the same. Just like with all things under the law, it almost always depends. However, prejudgment writs are something that we deal with all the time here, and would be more than happy to give assistance if it's something that you're looking for, whether it is the dispute does arise out of a simple breach of contract, or if there maybe are some more serious considerations in regards to attempts to defraud individuals or abscond from the state. We have experience with all sorts of different considerations that give rise to prejudgment writs, and would be happy to field any questions that you guys have. You can, my email address is there, as well as our firm phone number. I will close by saying that I am just a law clerk, and this is not intended to be any sort of legal advice or anything like that. But please do not hesitate to give a call to any of the lawyers here at the office. Like I said, we have plenty of experience with this, and would love to help you guys in anything that you need help with. Really appreciate everyone for taking the time to visit today, and hope this was enlightening. And like I said before, please feel free to pass on any questions that you have. Thank you.